Namaste and welcome to Daily News Simplified, the what, why and how of newspaper reading. Today we would be analyzing the Delhi edition of the Hindu newspaper of 14th May 2018. Now let us begin. Now we have taken this article from page 7. Now the reason this article is in the news because the Supreme Court has stated that domestic relationships includes any relationship between two people who either live at the present moment or have at any point of time in the past lived together in a shared household, wherein the Supreme Court has further added that the Prevention of Domestic Violence Act extends to all man-woman relationship, which includes divorced women, and therefore the case of domestic violence can continue after a divorce if the former husband still resorts to violence. And this violence can be in form of trying to dispossess the woman from a jointly owned property, refusal to give back valuable security or other property, and other forms of domestic violence. Now, hopefully, up till here, you have understood that the Supreme Court has held that domestic relationships include any relationship between two people who either live in the present moment or have at any point of time in the past lived together in a shared household. Wherein, moreover, according to the Supreme Court, the Prevention of Domestic Violence Act of 2005 extends to all man-woman relationship, wherein it is also extended to divorced women as highlighted in the article, wherein a case of domestic violence can continue after a divorce if the former husband continues to resort to violence, which can be in the form of trying to dispossess a woman from a jointly owned property, refusing to return to the woman her property, valuable security, among other forms of violence. Now, apart from this, what you should also understand is that domestic relationships is not confined to the relationship as a husband and a wife in a nature of marriage, but it also includes other relationships such as sisters, mothers, among other forms of relationship between a man and a woman. Now, with regards to your UPSC syllabus, the Domestic Violence Act and the recent verdict of the Supreme Court, as highlighted in this article and within this section, would be placed in GS Paper 2 in the Governance and the Social Justice section, more specifically, laws constituted for the protection of vulnerable sections. And so now with this, we move on to the next article. Now we have taken this article from page 11. Now the reason this article is in the news, Indian Space Research Organization or ISRO is currently undertaking research in a green monopropellant blend of fuel. Now before moving further, you should understand as to what is a monopropellant. Now monopropellant is a chemical propulsion fuel which does not require a separate oxidizer, wherein an oxidizer is a type of chemical which a fuel requires to burn, wherein most types of burning on Earth use oxygen which is prevalent in Earth's atmosphere. But however, in space, there is no oxygen or any other form of oxidizers. So rockets need to carry their own oxidizer. Now hopefully up till here you have understood as to why this article is in the news. Because the Indian Space Research Organization or ISRO is undertaking research in forming a green monopropellant blend of fuel, wherein for your basic understanding, a monopropellant is a chemical propulsion fuel which does not require a separate oxidizer, wherein an oxidizer is a type of chemical which a fuel requires to burn. So for example, most types of burning on Earth use oxygen which is prevalent in the atmosphere. However, in space, there is no oxygen or any other form of oxidizers. So rocket fuels require their own oxidizers. Now the reason a green monopropellant blend of fuel is required. Now it is required because ISRO intends to replace the conventional rocket fuel that is currently being used, which is called hydrazine. Now the reason it is required to be replaced because hydrazine is a highly toxic and corrosive chemical which is also carcinogenic in nature, wherein carcinogenic means it has the potential to cause cancer. Now the reason why hydrazine is currently being underused because it has one of the highest specific impulses, which is the kilogram of thrust obtained by consumption of 1 kilogram of propellant in 1 second. Now hopefully up till here you have understood as to why is a new green fuel required. Now a new green fuel is required by ISRO so as to replace the conventional rocket fuel which is currently used called hydrazine. And the reason hydrazine is being replaced because it is highly toxic and corrosive and also has the potential to cause cancer and is therefore carcinogenic in nature. But hydrazine is currently being used because it has one of the highest specific impulses, wherein it has one of the highest kilogram of thrust obtained by consumption of 1 kg of propellant in 1 second. Now the next question that arises is, what is the new green propellant being prepared? Now the new green propellant being prepared is a monopropellant blend which is based on hydroxyl ammonium nitrate, which specifically contains ammonium nitrate, methanol and water. Now the last question that arises as to where it is being prepared. Now it is being prepared at the Liquid Propulsion System Center, which is located in Thiruvananthapuram in Kerala. Now hopefully up till here you've also understood as to what is the new green propellant being prepared, wherein the new green propellant being prepared is a monopropellant blend which is based on hydroxyl ammonium nitrate and more specifically ammonium nitrate, methanol and water, wherein ammonium nitrate controls the burn rate and lowers the freezing point of the propellant, while methanol reduces the combustion instability of the fuel. And the last question that you should understand as to where is it being prepared. And this new green propellant blend is being prepared at the Liquid Propulsion System Center located at Thiruvananthapuram, Kerala, which is under ISRO. Now in terms of your UPSC syllabus, wherein the green propellant would be placed in your GS paper 3 in the section Technology, in the subsection Science and Technology Development, moreover in the subsection Indigenization of Technology and Developing New Technology, and further in the awareness in the field of space. And so now with this, we move on to the next article. Now we have taken this article from page 10. Now the reason this article is in the news is that the Supreme Court, in a case with regards to prison overcrowding, has given several orders and observations, wherein the first main order of the Supreme Court is that the Supreme Court has asked each High Court to take matters of overcrowding of prisons within their jurisdiction by themselves, and they can take the assistance of the State Legal Services Authority and the High Court Legal Services Committee, as serious issues of human rights violations are involved. The second order of the Supreme Court is that the Supreme Court has also told the High Courts to report back on the conditions of the prison within their respective area and come up with probable solutions for lessening the overcrowded prisons. And the third main order of the Supreme Court is the Supreme Court has also asked the Chief Justices of each High Court to take up the issue of staff vacancies in prison through writ petitions under Article 226. Now apart from this, the Supreme Court has taken an observation on the release of under trials, wherein NALSA or the National Legal Services Authority has informed the Supreme Court that a standard operating procedure for the release of under trials is ready. And as per the standard operating procedure, under trial review committees shall be set up in each district, and these trial review committees will deliberate and recommend the release of under trials and convicts who have undergone their sentences or are entitled to be released from jail due to bail or remission granted to them. And apart from this, the Centre has also informed the Supreme Court that the Ministry of Women and Child Development was conducting a study on women prisoners and their children, and this study would be completed by 30th June. Now with regards to this article, you have to understand that this news is currently in transition, wherein we have to wait and see on how each High Court moves forward with the orders of the Supreme Court on prison overcrowding. And similarly, we also have to wait on how the under trial review committees under the standard operating procedure formed by NALSA moves forward. And in similar terms, again we also have to wait for the study of the Ministry of Women and Child Development on women prisoners and their children, which would be completed by 30th June. And therefore, several aspects of this article are currently in transition. And so therefore, we move on to the next article. Now we have taken this article from the editorial page on page 8. Now what this article talks about is the critique of the terms of references of the Finance Commission. Now this critique of the terms of references of the Finance Commission has been covered extensively in the DNS of 12th April and the DNS of 13th April, which was covered by Maharishi ma'am, wherein this article makes a similar argument which had earlier already been covered in the DNS of 12th and 13th April. And therefore, you can refer to the DNS of 12th and 13th April to further understand the critique of the terms of references of the Finance Commission. And because of this, we would not be covering this editorial today. And therefore, we move on to the next article. Now we have taken this article from page 13. Now what this article talks about is that when the Insolvency and Bankruptcy Code was introduced in 2016, it classified company creditors into two categories. The first is financial creditors, such as banks and financial institutions, and the second as operational creditors, such as suppliers and vendors. But however, it did not address the position of other creditors, such as customers who had made advance payments. Now, this issue arose because several real estate companies that had been filed under the Insolvency and Bankruptcy Code had various customers who had paid advances for their flats or real estate, and this law did not address their position, such as how they would be compensated, among other factors. So, an amendment was brought in 2017, and a new rule was introduced, and this created a new category of creditors, which was called other creditors, which are all creditors other than the financial or the operational creditors. And this enabled other creditors to file a claim against a firm under insolvency. Now, hopefully, up till here, you've understood that the Insolvency and Bankruptcy Code of 2016 classified company creditors into two categories, wherein the first category was financial creditors, such as banks and financial institutions, while the second category was operational creditors, such as the suppliers and the vendors. However, this did not address the position of other creditors, such as customers who have made advance payments. And this issue arose because the real estate companies had customers who had made advance payments for their flats or real estate but could not be classified as either financial creditor or the operational creditor. So an amendment was brought in 2017 wherein a new rule was introduced which created a new category of creditors, namely other creditors, and this enabled these other creditors to file claim against a firm which is undergoing insolvency. However, the article has raised various issues with this rule, wherein the first issue is whether advances paid by customers would be treated similar to the debt the company owes to other creditors. And the second issue is the order of priority of the repayment which would be made in the insolvency process, wherein this issue of grey area will be clarified by the Supreme Court. So now hopefully up till here you've also understood the issues with regards to the new category of creditors that have been formed under the Insolvency and Bankruptcy Code, wherein the first issue is whether the advance by other creditors, such as customers of real estate companies who have made advance payments for their flats or other real estate, would be similar to the debt owed by that company to financial and operational creditors. And the second issue as to what would be the order of priority of repayment to be made under the insolvency procedure. Now, these issues form a grey area with the insolvency and bankruptcy codes, which have been highlighted in this article. And this grey area and these issues would be clarified by the Supreme Court. So, we'll have to wait and see as to what will be the observations made by the Supreme Court. Now, hopefully, you have understood the focus of this article with regards to the grey area in the Insolvency and Bankruptcy Code. And so, now with this, we move on to the next article. Now, we have taken this article from page 13. Now, the reason this article is in the news is because the government of India is planning to form an official definition of shell firms. And the government is planning to form a definition of shell firms so as to help the investigation by regulators and to ensure prosecution can withstand scrutiny in a court of law. Now, hopefully, up till here, you have understood as to why this article is in the news. Because the government of India is planning to form an official definition of shell firms. And the government is planning to form an official definition of shell firms so as to aid investigation by regulators and also to ensure that prosecution can withstand the scrutiny of law in a court in India. Now, the definition under consideration is first from the OECD, or the Organization for Economic Cooperation and Development, which has defined a shell company as being formally registered or incorporated or otherwise legally organized in an economy but which does not conduct any operations in that economy other than in a pass-through manner. Apart from this, another definition is under consideration from SEBI, which is that entities having no significant operational assets or businesses but acting in a pass-through capacity as conduits. Now, hopefully, up till here, you've also understood the two definitions that are under consideration by the Government of India for defining a shell firm or a shell company, wherein the first definition is used by the Organization for Economic Cooperation and Development, or OECD, which has defined a shell company as being formally registered, incorporated, or otherwise legally organized in an economy, but which does not conduct any operations in that economy other than in pass-through manner. And similarly, SEBI has also suggested a definition, which is that it is entities having no significant operational assets or business, but acting in a pass-through capacity as conduits. Wherein, in both these definitions, pass-through capacity means that those companies that are only set up on paper and kept dormant for future use of financial maneuvering. Now, in terms of your syllabus, this article would be placed in GS paper 3. As I've previously stated also, there might be articles or topics which may be placed in two or more sections, wherein this article would be placed in economic development as well as in the security section, wherein you might understand its placement in the economic development section, but in security, it would be placed in the subsection money laundering and its prevention, wherein a question was asked in GS paper 3 in 2013 with regards to money laundering and what steps are required to be taken to control this menace, and wherein having a proper definition of shell companies which take part in money laundering can be considered as one of the steps required to control this menace. Now you have to understand that this news is currently in transition, wherein we have to wait and see for the government of India to come up with a definition of shell companies or shell firms. And so now with this, we move on to the next article. Now we've taken both of these articles from page 14. Now the reason both of these articles are in the news is because the Directorate General of Hydrocarbons or DGH has announced the completion of the first round of bidding under the open acreage licensing policy as part of the new Hydrocarbon Exploration and Licensing Policy or HELP. Now what we'll do with regards to both of these articles is first understand as to what is the open acreage licensing policy and the hydrocarbon exploration and licensing policy, and then understand as to what are the issues that have been raised by the author in the first article with regards to the recently concluded bids of hydrocarbon blocks. Now the first question is as to what is the open acreage licensing policy. Now the open acreage licensing policy was introduced in 2017 as part of the new hydrocarbon exploration and licensing policy or HELP, which in itself was introduced in 2016, wherein the new hydrocarbon exploration and licensing policy replaced the earlier new exploration and licensing policy or NELP. And under this new policy, there would be a uniform license for exploration and production of hydrocarbon. And moreover, the new hydrocarbon exploration and licensing policy or HELP provides for freedom of marketing and pricing of crude oil and natural gas that is produced. Now the second question is as to what is the open acreage policy. Now the open acreage licensing policy pursues an open acreage policy wherein investors are able to choose exactly which area they intend to explore and develop, and thereafter they have to convey it to the Government of India, and then the Government of India places that area in a form of a block for competitive bidding. And under this bidding process, the original investor can explore and develop for hydrocarbons within that particular area. Now the third question is, how is the policy of open acreage under the open acreage licensing policy different from the earlier new exploration and licensing policy or NELP? Wherein under the earlier new exploration and licensing policy or NELP, the government used to select an area, then place it in a block, and the investor would have to bid for the entire block even if the investor wanted to explore a small area. And wherein under the new policy of open acreage and licensing policy, investors are able to choose exactly which area they intend to explore and develop for hydrocarbons and can bid for it through competitive bidding. Now the fourth question is, what is the change in the licensing system under the new hydrocarbon exploration and licensing policy or HELP? Now under the new HELP policy, developers do not need to apply for a separate license for each of the hydrocarbon they want to extract from that block, wherein they can obtain a single unified license to extract and market oil, gas, coal bed methane, shale gas, and shale oil. Now the fifth and the last question is, what is the change in the revenue model under the new policy of hydrocarbon exploration and licensing policy or HELP? Now under the earlier new exploration licensing policy or NELP, the profit was shared between the company and the Government of India, but it led to complications in ascertaining what constituted the cost and what constituted the profit. And therefore, under the new policy, HELP, it pursues a revenue sharing model, and therefore there is no ambiguity as to what constitutes cost or what constitutes profit. Now hopefully you have understood the basics of the open acreage licensing policy and the hydrocarbon exploration and licensing policy, and also further understand on how it is different from the earlier new exploration and licensing policy or NELP. Now let us understand as to what are the issues raised in the first article with regards to the recent announcement of the completion of the first round of bidding under the open acreage licensing policy, which is part of the hydrocarbon exploration and licensing policy. Now, this article raises issues with the open acreage licensing policy and the hydrocarbon exploration and licensing policy. Now, the first issue raised in this article is the monopoly of GAIL over marketing and transporting of natural gas, where it has been alleged that the monopoly of GAIL allows for discriminatory and unfair practices, such as differential pricing for different players. Now, the second issue raised in this article is the response to global oil prices as to whether the oil companies should pass on or absorb the losses due to fluctuations in global oil prices. Now, the issue arises when there is an increase in the global oil prices, whether the oil companies should pass the increase in prices to the consumer or whether they should absorb the increase in prices themselves, thereby leading to losses. Now, the third and the final issue raised in this article is that it is required to bring petroleum products and gas under GST. And this is required because to avoid the cascading effect of value added taxes that have been imposed by states. Now, hopefully, up till here, you've understood the three issues that have been raised in this article with regards to the open acreage licensing policy and the hydrocarbon exploration and licensing policy. Wherein the first issue is the monopoly of GAIL over the marketing and transporting of natural gas, wherein the monopoly allows GAIL discriminatory and unfair practices such as differential pricing for different players. The second issue raised as to what should be the response to global oil prices, as to whether oil companies should pass or absorb the losses due to fluctuations in global oil prices. And the third and the final issue raised in the article is that it is required to bring petroleum products and gas under GST so as to avoid a cascading effect of state taxes. Now, with regards to your UPSC syllabus, the exploration of hydrocarbons in India would form a part of GS Paper 3 in the economic development section, more specifically infrastructure, energy, wherein previously a related question has been asked in your UPSC examination, which was asked in GS Paper 1 in 2013, which had asked to discuss critically the availability and issues involved with regards to the reserves of shale oil and gas in India. Now, as I've said earlier, certain articles and issues overlap within multiple papers and multiple sections, wherein a question on shale oil and gas and the issues involved in tapping this resource was asked in GS Paper 1 within the section Geography of the World and Society. So I also recommend, so whenever you read an article in any newspaper, magazine or otherwise, always write down as to which part of the syllabus would this article be under. And now with this, we come to an end in the analysis of today's paper. Now we move on to the question for today.